And having got myself to that point, I really will go forward and just quickly address a fascinating question from Walter Plant, because this notion of a developing individual-specific tradition, national tradition, as opposed to a universal doctrine of proper political arrangements, is very much at the heart of the next question. Walter says, I'd be very interested to hear you talk about the evolution of law, focusing on the decision to create a Supreme Court and the changing role of the Lord Chancellor against the historic backdrop of our court system. I would also welcome your addressing the issue of whether our courts should be paramount authority in the UK against the backdrop of our history, my contention being that in these islands the body politic has not historically been able to subvert the judiciary. Actually, I think, Walter, you are absolutely wrong. The tradition in these islands is that the supreme authority is political. It is the authority of Parliament. It is Parliament that makes the laws. There is no separate body of constitutional law. There were terrible danger of creating the European Convention on Human Rights into such a quasi-body that instead Parliament is sovereign, and it is the job of the judges to interpret law which is either made by Parliament or, even if it's common law and inherited, can be changed by Parliament. So how does that relate to the point that I was just making now about Disraeli and about Burke? If you look at the changes that are highlighted here by Walter, setting up a Supreme Court, the changing role of the Lord Chancellor, these were all done under Tony Blair, under the neo-revolutionary regime of Blair's tenure regime. The 10-year premiership. What was it about? What drove the idea of the creation of the Supreme Court? What drove the altered role of the Lord Chancellor? Well, of course, partly the reason that the position of the Lord Chancellor was changed was that the Lord Chancellor at the time, Derry Irving, had actually been Tony's pupil master when he was a trainee lawyer, when he was a barrister, and was overweeningly arrogant, indulgent and powerful, and Tony wanted to cut him down to size, and the most effective way of doing that was to demote the position of Lord Chancellor, which duly happened. So there was the highly specific, localised, deeply personalised politics going on there, but there were the general ideas. And what are the general ideas behind the removal of the traditional authority of the Lord Chancellor, behind the setting up of the Supreme Court? Well, they all derive, and I've talked about this before, they are French. All bad ideas, as we've announced, the Starkey Doctrine, are French. These are the ideas of Montesquieu, set out in his great systematic treatise, the Spirit of the Laws, which allegedly incorporates his experiences in England, when he's living in England in, I think it's the 1730s. He is supposed to have systematised the British Constitution. I've actually been able to show he barely spoke a word of English, and his notion of what the British Constitution was in fact based on an extraordinarily eccentric pamphlet by a strange, marginal, odd conservative thinker called Viscount Bolingbroke. Anyway, but what are the general principles of the Spirit of the Laws? Well, they are profoundly influential. The idea that there are three separate branches of government: the legislative, that corresponds in our case to Parliament; the executive, that corresponds to the Prime Minister, acting as the embodiment of the royal prerogative; and finally the judicial, which is the judiciary, the whole structure of courts, now headed by the Supreme Court. The idea is that in every properly constituted state, those three powers should be separate. There should be a thing called the separation of powers, which you see very, very clearly expressed in the American Constitution, although the American Constitution formulated in the 1770s and 1780s, although the American Constitution derives directly from the British. I mean, why is the person in charge why is the chairman of the House of Representatives called the Speaker? Why is the administrator of the House of Representatives called the Sergeant at Arms? Because of course the British Parliament has a Speaker and it has a Sergeant at Arms. And manifestly the Senate is an elective version or quasi-elective version of the House of Lords, the President of the Sovereign, and so on. But what the Americans did, profoundly influenced by Montesquieu, was to produce the separation of powers. So you have all three branches directly, in one way or another, resting on some sort of principle of election. Why judges are elected, and so you have an election which yields the House of Representatives, and now after a constitutional amendment after the First World War, there's also direct election for the Senate. Before that, it was actually nominated representatives from the legislatures of the constituent states of America. So you've got that body, the legislative, derives directly from the will of the people. The president is, again, the idea was that he was indirectly elected, which is why you have the Electoral College, but the Electoral College has never really worked. But it does perform a moderating function on the as it were, the general election, the general verdict of the people, which is why you can get presidents who have a minority of the popular vote but still carry the vote within the Electoral College. And then finally you have the much less defined, but as developments took place in the early 19th century, the equal power of the Supreme Court. Three powers, in a sense, arguing with each other and debating with each other, which is why so frequently American government suffers from stasis. Britain does not have that. Traditionally, the Parliament was all three. Why Montesquieu misunderstands completely. The Parliament is the assembly of the King, Lords and Commons. It is the supreme body of judicature, which is why until recently, until the creation of the Supreme Court, the House of Lords itself, the subcommittee of the House of Lords, was the final court of appeal. The Prime Minister, the executive, the centre of the executive, sits in the lower house. Until the 19th century, could sit in either house of Parliament from the advent of democratic election, democratic franchise. He invariably sits in the lower house, in the House of Commons, and the Lord Chancellor. That's right. The final piece in this jigsaw. The Lord Chancellor was, of course, both a member of the cabinet, responsible for the oversight of the judiciary, and indeed as it were, the pinnacle of the judiciary and the presiding officer, insofar as there was one, in the House of Lords. Now, this system worked extraordinarily well, but for Blair and his acolytes, it didn't correspond to the standardized rules. So what they started to do was to begin to unpick it. The first thing you did was to take to strip the Lord Chancellor of his general oversight of the judiciary, to remove him from his position as presiding officer in the House of Lords, and to make it simply a decorative title for a kind of Secretary of State for Justice. Indeed, the original idea was to abolish the position of Lord Chancellor entirely, and that was the work of Charlie Faulkner, who was Blair's flatmate. Faulkner was so pig ignorant that he didn't realise that the position of Lord Chancellor was absolutely interwoven with about, until very recently, a quarter of legislation, and therefore the attempt of the abolition of the Lord Chancellorship would have required the writing of a very substantial part of statute law. So what you had to do was to allow the Lord Chancellor to continue as a title, but attach it to the Secretary of State for Justice. Now, the result of this, of course, has been a quite remarkable diminution of the political weight of the judiciary, or rather, not the political weight, but the regard with which the judiciary were held by the political class. So much of the starving of our courts of finance, the mishandling of both programs of modernisation of court buildings, the mishandling of prisons, the mishandling of legal aid would have been inconceivable in the regime of the old powerful Lord Chancellors, Derry Irving himself for Labour, or somebody like Mackay of Clashfern under Margaret Thatcher. They simply wouldn't have stood for it. So the legal system has suffered very badly from the application of this absurd generalised rule of the separation of powers. And of course, it's worked the other way round too. Once you created a Supreme Court, you then do move very dangerously towards the position that Walter seems to regard as a good idea. That's to say that the law should take precedence over politics, over political decisions. I think that's a really bad idea. I mean, look at what it led to in America. It led to the fact that you get things like Roe versus Wade, the decision as to whether there be abortion available on a federal basis, a basis entrenched in federal law. You got it taken not by Congress, but by the Supreme Court. In other words, you immediately remove any level of democratic legitimacy for that. That's why the issue of abortion has remained such an unhealed sore in American politics. That, of course, and the fact that there is still a much more serious level of Christian fundamentalism in America than there is in Britain. But the use of law to enforce political decisions which do not command democratic assent, it seems to me, Walter, is profoundly dangerous. Isn't that the fundamental problem with the EU? That the EU, again, I did the video on the Schuman Declaration. The Schuman Declaration, going right back to the beginning of the EU, is consciously an elitist conspiracy against an idea of democratic consent. This seems, and you give a body of, when you set up the European Court and Steel Federation, you create a high authority that has quasi-judicial authority over states, over entities, over individuals. This just seems to me, finally, to be wrong. On the other hand, there are enormous pressures forcing us in that direction. The extent to which all jobs are being professionalized, which involves the creation of separate sets of rules which are then enforced quite irrespective of the law of the land, or indeed in actual defiance of the law of the land. The extraordinary business, for example, where it comes to resisting the floods of illegal immigrants across the Channel, where you actually get the border force saying, no, we won't do it because we don't think that it's the law. We don't, and our own moral principles challenge it. We are in terribly, terribly deep waters, and we were never in deeper waters than in the decision of the Supreme Court to interfere over the matter of the prorogation of Parliament. This is utterly and infinitely dangerous. The Stuart kings in the 17th century tried to use law and their control of the judicial system to control Parliament. Parliament resisted absolutely, and in the Bill of Rights of 1689 it is stated absolutely clearly that proceedings in Parliament are not judicable in any other court. And yet what the Supreme Court did was to twist that. It claimed that when a parliament was prorogued, which of course means that it's just suspended, its sitting is suspended for a few days, a few weeks or whatever, it somehow is no longer in existence and is no longer fulfilling its function, despite the fact that prorogation, going right back to the 16th century, has always been used as a piece of necessary parliamentary management, as indeed Boris Johnson was using it. The idea, of course, that everything must be subject to the rule of law will, again, as we are seeing from Rag MP, will itself challenge things like whipping. It'll challenge the structure of the party system. And Walter, very simply, the idea of the absolute rule of law too quickly becomes the rule of lawyers. It too quickly becomes the rest of us being run by the unelected, by the great and the good, by the professions, by the civil servants, by the universities, by people who think they know best. In other words, it is a recipe for replacing Burke's living, functioning Constitution of Britain with a version of Plato's Republic based upon a noble lie and an elite that is irremovable. I don't want that. Do you? Hello, and thank you for watching David Starkey Talks. If, as I very much hope, you're enjoying them, why not become more actively involved and join my members club? As a member, you'll be able to take part in the members-only weekly question and answer session, suggest topics for forthcoming videos, and have priority booking for my forthcoming live events. And while you're at it, why not have a look at the store page on my website, davidstarkey.com. There you can purchase T-shirts and other merchandise, buy signed copies of my books, and, if you're feeling brave and a bit flush, even arrange to take me out to lunch. Thank you once again for watching. I look forward to hearing from you and to welcoming you to my members club.